Well, good afternoon to you all. Thank you very much all for being here with us today. It's a real pleasure to have you. I am absolutely delighted to present this second panel today, which focuses on the politicization of human rights in the corporate world. So we're going to be looking at the issues of the politicization of human rights, but from a different angle. This morning, we looked at the European aspect and the European perspective and dimension. And today, this afternoon, we're looking at a different dimension, which is business and human rights one. And I'm truly delighted to present the stellar panel that we have today. Thank you all very much to the speakers who have accepted our invitation. It's a pleasure to have you here. And without further ado, I'd like to give the floor to our first speakers. So we have two speakers. It's Dr. Chiara Hackett and Dr. Luke Moffat. So Luke and Chiara are both lecturers at the law school at Queen's University in Belfast. They are both interested in remedy, but come in the space from different backgrounds. Luke's primary research focuses on reparations in international criminal law, human rights law, and transitional justice, and is heading up several international projects in the area. Chiara comes to remedy from a background in corporate governance and private law. The work together looks at the convergence of ideas of remedy and reparations within their respective research areas. So I will now give the floor to Luke and Chiara. You have 10 minutes and then we'll have the discussion of your paper after that. Thank you very much.
Thank you, Claire. I'm just gonna try and share the screen, first time ever. So let's see if it works. Can everybody see that okay?
Absolutely.
Great, good stuff. Okay, so our paper is looking at politics, the role of politics basically in ensuring remedy for corporate violations of human rights. So what I'm going to do in this presentation is, rather than focus on what we did in the whole paper, I'm going to just break it down as much as I can in 10 minutes. I will say that this is a very early draft of an article, so I welcome any and all feedback that you might have. So essentially, we are looking at this question: how we can motivate and incentivize corporations to address their corporate violations without degrading victims' right to remedy. So we've approached this in three different ways. We firstly look at where is it that corporations see their obligations, or where do corporations turn to get a better understanding of what their human rights obligations might be. Our second point then is, why do corporations remedy? And then our third point is, how does the law and politics influence the corporate interaction with human rights? And is this a good thing? Is it a bad thing? Does it inhibit the potential for corporate interaction with human rights? So to do this, we have, for the purposes of this presentation, we have looked at the recent Rio Tinto scandal of the mining in the area of an Indigenous burial ground. And specifically, if you look at their response to this event, so they issued an apology, they committed to working with affected communities, and they committed to working with the Australian government to review the Aboriginal Historical Sites Act 1972, and they fired their CEO. So just keep that in mind, and we looked at that first question identified at the start, the corporate motivations. Where do they turn to understand their human rights obligations? So here I have taken a UK focus. So the first place that corporations might look for guidance is to domestic law. And in the UK, there are three main points to be aware of. Corporations have obligations to those that are affected by their activities. And this includes their supply chain. And we know that from the Chandler and Cape case, but also then from more recent cases like the Vedanta case, and quite possibly from Occupy, but we're not quite sure on that yet. The next thing is legislative obligations, which refer typically to specific human rights issues. So for example, the Modern Slavery Act, Bribery Act, and then you also have more general provisions outlined in the Human Rights Act, the Equality Act, and health and safety provisions. And as well as that, you have common law provisions based primarily in tort law, such as obligations to the employees, but also a bit more to wider society as well. And you have deferred prosecution agreements within criminal law as well. For international law, we look to the soft law guidelines, typically with your OECD guidelines, and as I've used the example here, the United Nations Guiding Principles on Business and Human Rights, and particularly that second pillar, the corporate responsibility to respect human rights. But a third area where we think that corporations might look for guidance is to corporate governance. And we do think that this is maybe an area that is a bit more neglected within the business and human rights literature. So basically, your viewpoint on corporate governance comes from three main theoretical perspectives on the role of the corporation. The first perspective that developed from economists is this idea that the only obligation that the corporation has is to maximize the profits of its shareholders. Now, this obviously developed in a vacuum, and it doesn't take into consideration the fact that corporations have to operate in society. So it has evolved with the impact of legislative advances to this enlightened shareholder value approach. So for example, in the UK, there is a requirement in company law to state how corporations take into consideration other aspects of the community. The second approach then looks at the value chain of expertise, and this is your resource dependency output, where the corporation is still very much focused on profit maximization, but recognizes the power in having a good network of expertise both within and outside the corporation to advance the corporation's interests. And the third one then are your stakeholder theories, which broadly recognize that the corporation has an obligation to those who are impacted by the corporation's activities. So this is your social contract theories, and focus very much on how the corporation accounts for taking into consideration the role of others outside the corporation. So why do we consider this? Well, we think it's important because it will provide an insight into how the corporation might understand their human rights obligations. And we do this because each of these theoretical perspectives all take into consideration corporate social responsibility, and they attempt to situate CSR within their different theoretical perspectives. Whereas we know obviously CSR and business and human rights are different, there is enough of an overlap there to perhaps gain some insight as to how then corporations perceive business and human rights. So to go back then to our Rio Tinto example, and why might a corporation remedy harm? Did Rio Tinto remedy because they recognized the hurt that they had caused? Had they been legally bound to do so? Did they need access to the resources in the area for future projects? Did they have mining operations elsewhere and did not want to negatively impact community relations? Was their share price affected? Had institutional investors campaigned against them? Was it because of bad publicity? Or was it simply because they were aware of their international responsibility to respect human rights and to remedy harm? Well, to do this, we think that we need to consider the motivations to remedy. And in this part of the paper, we look particularly at Dennis Arnold's categorization of human rights within the business context. And he looks at human rights as types of demands. He looks at the moral demands, so this is recognition of wrongdoing, the political demands, so this typically is things that the corporation can account for so that they can manage through reporting or through PR, for example. And then you have your legal aspect, which for Arnold is very much grounded in positive law. We have added a fourth here, taken into consideration your corporate governance theories, which is the economic or the financial element. So why does this motivation even matter? Well, we believe it matters because it gives us insight into how the corporation perceives human rights and their responsibilities. And it also allows us to see how this respect of human rights might be proceduralized or characterized within the business model. Okay, so how can it be presented in a way that is palatable to the corporation, but again meets its obligations to wider society? So to go back to the Rio Tinto example again, we've divided those into moral reasons, legal reasons, political reasons, economic reasons. And as you'll see there, if you look down the slide, the majority of the reasons have some element of political rationale there, okay? So then our third point is, how does the law facilitate, enable or challenge this way of doing business? Well, the first way that it does is through due diligence initiatives. And this very definitely was something that emerged, a real positive, should I say, that emerged from the United Nations guiding principles, in the way that it forced corporations to think about their human rights obligations and to account for them in the form of their due diligence reporting. And this has made its way into the new draft treaty, particularly in Article 6. Now, whereas we recognise the importance of due diligence, we are a little bit concerned about the specificity of Article 6.3, because we do think that this maybe could lead to a tick box exercise. And in our paper, we do recommend the Claire O'Brien draft treaty wording. We think that it may be more effective in invigorating the corporate form to respect human rights. However, we do very much welcome Article 8.8 of the draft treaty, which notes that due diligence does not preclude legal liability. The second point then that we look at are the different domestic routes to remedy. And we highlight particularly the Alien Tort Claims Act, the French due diligence provisions, and the Modern Slavery Acts in both Australia and the US. We note the positives, that this does provide a route to redress for victims, but we do highlight that there are certain limitations to this. For example, the Alien Tort Claims Act only incorporates particular rights. For example, there's no economic, social and cultural rights protected under the Alien Tort Claims because they're not perceived to be part of the law of nations. We do think that the domestic routes highlight a cherry picking of rights and does create a hierarchy of victims, because some countries will have better resources than others, and also then a better recourse for victims. And as well as that, then you have the various procedural barriers, such as statute of limitations, who can take a case, the various procedural hoops that need to be met. And then our third point then is our claims making beyond the law. And Luke, maybe we want to come in and speak to this.
Yeah, thanks, Ciara. I suppose with the treaty and with the domestic legal routes, and also our fourth point that we'll talk about, these are all mechanisms that have came about, their outcomes, or soon to be outcomes of the draft treaty. Really, what we've been exploring in this third part is the role of politics in sort of encouraging or incentivizing corporations to engage in remedies for victims, where often there's gaps or there's a weak legal structure in order to get corporations to remedy victims' harm. And so in the paper we talk about the Swiss banks, the German corporations for forced labour. But a more recent example that's came about in the last couple of weeks has been the role of Volkswagen in Brazil, whereby it's created this reparation scheme for victims who lost their jobs or suffered torture as a result of Volkswagen's complicity with the military regime there. And what's interesting there is not just the role of victims bringing claims to the courts, but also how it looks politically. And so it very much ties into Arnold's sort of typology of claims making, that it is moral, it is legal and political, but I think it also speaks to the corporate responsibility, and that for corporations, they want to ensure legal peace. They want to sort of consolidate all claims against them and ensure that they don't arise again. And so for some of the victims on the ground, and also the political context in Brazil under Bolsonaro, is that you don't really have this sort of civic space to push for more. So we talk about this in the paper, and it's trying to understand maybe the why and the how of actually remedy resulting beyond the law, whereby we can talk about human rights obligations for non-state actors, but also the gaps that there are in domestic legal systems, that human rights only gets us so far. And so it's trying to see the gap between what the law says and also then seeing that in reality and implementing redress for victims. And the danger with this, and Ciara and I've talked about this in a previous paper, is the danger of diluting victims' rights by engaging in corporations in this. So I think that'll cover enough at this point. If Ciara's going to take over then for the next bit.
Okay, thanks, Luke. And finally, nearly to build on Luke's point there, going beyond the law as well, we also have your national contact points and those non-judicial state-based grieving mechanisms. they're useful in that they showcase the types of rights that can be adjudicated for, and that they ensure some pathway to remedy. But as actually I'll talk about later, there is very little remedy that's actually available for the victim in the here and now, and it may be more forward looking. But the purpose of this, again, like what Luke was talking about, it's about publicly holding the corporation to account. It's a route for a political outcome rather than an industry-wide change in behaviour. So that brings us on really to the conclusions that we make in the paper, and it is that remedy is in effect political. You have all these interactions between trade and state, but the reliance on the state on trade and will mean that law is not necessarily enough to guarantee remedy in itself. So we need to think beyond those barriers. We need to think beyond the law. We need to think beyond corporate engagement for ways to ensure that victims receive that remedy. And as a result, then we say that access to remedy should be balanced on the resources and should not be balanced on the resources and influence of one state's domestic capabilities over another. Gosh, that's a terrible typo. And also how we need to rethink how we think about the corporation before we think about how it is that they address their human rights respect, and think about the importance of politicising remedy, because this might be the best route for victims. And I will leave it at that. Thank you.
Thank you very much to you both for a very interesting presentation. And I will now give the floor to Umberto Cantu-Riviera, who will discuss the paper. You have 5 minutes, Umberto.
Thank you, Clara. Yes, I'll be brief. Hi, Clara. Nice to see you again. And Luke, very nice to meet you. Thank you for this very interesting paper. I must say that the title is quite intriguing. So I read it with a lot of interest, and I have 3 overall comments that I would like to share with you before getting into maybe a couple of specific details. I really like the way you frame it. I think there is so much information here that it is really something that could easily be divided in 2 or 3 papers. I mean, it's just so much information that it is that wide in terms of the scope. But that is also one of the points I wanted to raise. While it is important to expand on the subject matter, which you do very clearly, it would be also important to make it, in some cases, clearer. And especially I refer to section 1, where you touch many, many, many different things, all of which are relevant, interesting, of course, but where there is at some point no sense of division between the ideas. So that would be, I think, helpful to actually understand more clearly how you're looking at the different angles of the same topic, right? Number 2, I would like to mention that there are many assertions that you make, which are of course quite interesting, but that I think could also benefit from some nuance. And let me give you a couple of examples, if that's okay. The first one is, for example, in page 6, where you mentioned that it is well established that corporations are bearers of responsibility as well as rights within international law, suggesting an increasing turn to see them as subjects. My question is, are they, or is it true that they are bearers of responsibilities under international law? And that's a very interesting question, because doctrinally, of course, everyone agrees that businesses should be subjects, direct subjects in many cases of international law. But what about the practice? I have not seen much practice about them being bearers of responsibility. And that is very important as well, because if you look closely at the treaty negotiations, you can see that, well, I don't recall any state actually saying, yes, we want to have corporations as subjects of international law. Maybe we can impose obligations, but let's not treat them as the same as we are. So that's a very interesting point, and I think some nuance there would be very helpful. Also in page 7, you mentioned that the law fails to identify how the corporation negotiates its relationships with the community that it operates in. And I was wondering, because a few days ago we are having the 30th anniversary of the adoption of the ILO Convention 169. And that made me think, what communities? And the law addresses which topics, right? Because this field is so vast, so broad, that maybe we cannot treat every single community the same way. For example, in the cases of indigenous communities, we have very clear stipulations in a treaty, in a UN declaration as well, and also in the case law, for example, of the Inter-American Court of Human Rights, where this is very clearly framed. How do we expect corporations and states actually as well to relate to communities? So that in itself is something that caught my attention, and I think some nuance would benefit for that. Maybe you should expand on that a bit as well, because it's a very interesting discussion that you're raising, but it would be helpful. And so not to abuse my time, because I know that I only have 1 more minute. I was wondering, as I was reading your last section, it sounds to me a lot to remedy and the issue of remedy in transitional justice, especially when you address the Volkswagen case, which is, in my view, a very interesting case, even though many CSOs are criticizing it because they say, well, they are buying their innocence. I don't think they're buying anything. I mean, it's a valid way of transaction that exists in domestic law in all jurisdictions, or many jurisdictions. So it's, I mean, a way to resolve a conflict that is acceptable under the law. But I wonder if you would be interested in looking at the conversation on this from the perspective of transitional justice, and to maybe explore how do they reinforce this discussion that you're having, because there's been so much on moving beyond this type of situations in transitional justice literature, especially in a couple of books that were recently released on this topic that probably could be useful. But overall, I find the paper very interesting, very structured, even though it could be clearer. But I think the conversation you're having here is a very important one, and hopefully we'll be able to see this in print soon enough. Thank you very much.
Chiara and Luc, if you want, you can respond. You have 3 minutes.
Sorry, here, I'll just go briefly. Humberto, thank you so much. That's really helpful feedback, and I completely agree. I think, and I really like your point about, you know, bringing out the sort of the different shades of community and trying to nuance that a bit. I think that's a really nice point. Really, you know, Kira and I are coming from this from very different perspectives, and we're saying the same thing, but we're just trying to see where everything fits. And I think we've still got a wee bit of work to do to make it all gel. But those comments are really, really helpful, and we'll definitely be taking those on board. Especially, you know, with the literature that they're very, you know, there's a lot of literature on the issue of remedy and transitional justice, and the emerging stuff of like trying to tease businesses into that. So yeah, we'll definitely engage with that. So thank you very much.
Yes, thank you, Umberto. That was really, really helpful. Yeah, probably as we wrote it, we realized that we were trying to do too much in the one paper. So it is something that we are going to have to address about how we can shave it down and maybe have more of a hook that we can unpack the issues rather than all the examples that go through it. But thank you very much. That's really helpful, and it definitely gives us stuff to work on to move it forward.
Well, thank you very much to all 3 of you. And now we are going to move from Ireland. We had our speakers based in Ireland, our discussant in Mexico, and now we're moving to the US. So that's the magic of internet, isn't it? So we are moving to our next speaker, Professor Bashar Malkawi. He's a global professor of practice in law at the University of Arizona. He's well versed in teaching and providing legal advice, has more than 20 years of experience in private and public sectors. His work covers a variety of subjects, but with strong emphasis on regional trade agreements, economic integration, and business law, broadly conceived. Bashar, the floor is yours. You have 10 minutes.
Okay, thank you so much for this kind invitation. I'm an old-fashioned guy, so I won't be using slides, so I'll be speaking. So if you could bear with me for the next 10 minutes. My paper is basically about the interaction between international investment law and human rights. And this is the issue or the reason for writing up this paper is that I did sort of comparison with the WTO law, and I thought that for the WTO law that so many WTO panels issued decisions that argued that we don't live in a or the WTO law does not exist in a separate sphere. It interacts with other laws, and the same thing applies for international investment law and human rights. And you could, if you look back at history, you'll see perhaps they don't share the same origin. We're talking about bilateral agreements between an investor and a state, or state to state through bilateral trade, bilateral investment agreements, BITS agreements, and there's sort of no multilateral investment agreement that can govern all these types of separate investment agreements or private contracts between investors and states. While we see for human rights that it came from different background, it came out of the World War II. It's universal by nature. There are so many universal conventions that protect human rights, but they have one goal, which is to protect the individual, whether it's an investor or other individual, from the interference of a state. Now, you'll see the interaction between international investment law, or FDIs, and human rights at multi levels. There are so many layers where you can see the interaction. So if you start, for example, referring, for example, to the issue of negotiations, you can see that for FDIs, bilateral investment agreements, or private contracts, you can see that it's shrouded with the privacy, that people or the civic community is kept in the dark with regards to the negotiations, while we don't see much transparency, especially when talking about private contracts between the investor and host state. As when we talk about of BITS agreements, you see a bit of transparency, but this comes after the fact, after the negotiations ended. So there is no civic engagement really in these types of negotiation. This is in stark comparison with what happens in the human rights side. You see a bit of or more transparency if you compare it with the investor side of the equation. Now, of course, the investment agreements are shaped by different interests. The ultimate goal, whether we like it or not, is to protect the investor interest in the host state. And we see especially so many developing countries where they sort of compete with each other for this sacred capital, so they can invite in more investors to come in and invest or sign different types of BITS of agreements. There's little regard in the minds of those negotiators the issue of human rights on their mind. And you can see this by the way how these types of agreements or contracts are drafted. They are vague in nature. They're more focused on the economic side of the equation rather than really on the human rights, on the environment or labor. There could be provisions that try to somewhat protect these types of interests, but they can be unenforceable. There are, of course, And so on balance, you'll see that the interest of the investors and economics tip in favor of the investor rather than in favor of human rights issues. And we see how countries compete for this type of capital. Now, if you move to the actual text of these agreements, you'll see different clauses. You'll see about the expropriation, direct or indirect expropriation, and the purpose of these provisions are really to protect the interest of foreign companies or foreign investors. There is a huge fuss about the issue of indirect expropriation. Rarely countries right now do direct expropriation. They use indirect expropriation. And when you look into the cases decided by investment tribunals or the actual text drafted by negotiators, you will see that the purpose once again is not to diminish the benefits and the rights given to the investor. So, and these types of provisions or articles with regard to indirect expropriation imposes limitations on the ability of a host state to enact a myriad of provisions or regulations with regard to the environment, labor, or human rights. If you look also, for example, at the fair and equitable clauses, that an investor should be given fair and equitable treatment, you'll see again that these type of provisions or clauses are shrouded with vagueness and not so much of a clarity. And if you look once again at the investment tribunals cases, you will notice that the focus is on economics, that these are really, and this is one of the investment tribunals decisions, that this is really an agreement will focus on the commercial terms, not the human side of these types of agreements. The same applies for the non-discriminatory provisions, whether we're talking about the MFN treatment, the most favored nation treatment, or if we're talking about the national treatment, that a foreign investment should not be treated worse or less than a local or a domestic investor. And again, you can see that there is little regard to the issue of human rights in the actual drafting. And this applies also to the civilization clauses, whether we're talking about the economic equilibrium clause or the freezing clauses, where there's no much room for maneuver for the host state. So laws would be frozen at the time when this investment contract was concluded. So if a host state desires to change the law to accommodate human rights interest or environment or labor, the state's hand is tied and cannot move beyond what was agreed upon perhaps so many years back. There is an interaction with third parties, and I mean by third parties amicus briefs that perhaps out of interest in a particular investment dispute, they desire to engage in this type of dispute, so as to express their interest about certain issues, whether human rights you're talking about or some other social issues. Now, if you look at so many cases that were taken upon by investment tribunals, you will see that in most of these cases, first, they were hesitant to accept amicus brief from non-party to the case. But then at a later stage, they accepted these briefs, and the environmental organization, human rights organization, were happy that they got now their chance to be heard at the tribunal level. But ultimately, the decision of so many investment tribunals that although they accepted initially these amicus briefs, but they were not taken into account when a decision was made. So this is so nothing really happened on this front. Now, you can see also the interaction between human rights and the investment by making references in some of the investment tribunals decisions, but these references though can be respected, but does not advance the issue of raising the bar for human rights protection at the same level as perhaps economic interests. In one case involving Argentina, even the Argentinian government directly raised the issue of human rights, that the action taken by were against human rights, but the investment tribunal in that case did not entertain this issue, and the focus was solely on commercial terms, or the commercial terms included in the investment agreement between the two parties. In this case, this is in case of direct invocation of human rights. So my argument in this paper that the interaction runs short between between human rights and investment, whether agreements or investment decisions made by investment tribunals. I think there is a hesitation of for those involved in the investment arena to adopt the human rights issues directly or right away. That's why perhaps I call the paper back and forth. So there is no clear standard where we're going. We're moving, seems one step forward, but we're moving perhaps two steps back. So in total, I would argue that human rights issues right now, as a current state of affairs, are not on the same bar as investment concerns or commercial concerns. There are tiny steps taken, perhaps by the acceptance of amicus briefs, but this really does not advance the issue of human rights at the same level as investment rights. So this is, I guess, the conclusion of my paper. Thank you.
Thank you very much, Fabrice Bachar. And now we'll give the floor to Chiara Nokeli and Chiara Hackett for the discussion of your paper. Chiara and Chiara, you have 5 minutes.
I'll go first. Thanks very much. I have to say we weren't aware that we would have to be we would be discussing, but that was a very interesting paper, Bashar, and thanks very much for it. I think it really raises. I mean, for me, it raises two questions about the politicization of law, and especially of human rights. The first is around kind of legal process as symbol. So when you talk about the tiny steps that are taken in terms of entertaining amicus briefs, but without much impact upon outcomes, that strikes me as being procedure without effect. You know, that it falls within the kind of the realm of symbolic politics, or of accountability without action, and highlights the limitations indeed of these processes. But for me, the more important and significant element to your discussion was around the idea, and I don't know what you have to say. I mean, I suppose this would be a concern for me when we talk about the role of host states in bilateral treaties. There's patently an inequality of power in bilateral trade agreements and investment agreements between larger economies and smaller ones. But you know, I think it would be wrong to say that host states are forced in a way to, or are inevitably being forced into downgrading human rights. There are, of course, very significant interests on the parts of host states to not entertain human rights, or at least to only entertain them in a surface manner. We should ask whether they want to protect rights, you know, and this can happen in, you know, at an extreme where the sovereign actor is in essence privatized or is acting as an agent for private parties who have a commercial and political interest in not entertaining human rights for subject populations. But it can happen at a less extreme level as well. And as somebody who watches the conduct of the Irish state towards its tax policies, for instance, I don't think that the Irish state is the victim of corporate actors there. I think the Irish state is a willing and enthusiastic participant in its own failings on that part, for that matter, perhaps for reasons that can be argued to be good, or perhaps for reasons that are less wholesome. So yeah, I would wonder whether you have something to say about that. You know, to what degree are host states actually interested in protecting human rights in investment treaties?
Yes, thank you for your comments. With regard to the first one, the amicus brief, yes, it's a step forward, but it's with its own limitations. They accepted these amicus briefs, but the end, when they made the final decision, it was not taken into account. But at least the tribunals had a chance to look into this case. I think they were a bit hesitant to do so or to accommodate interest, because this will have many ramifications, especially that really the focus of these types of agreements on the economics or the commercial side. Now, with regard to your second point, the host state, we've seen that so many countries worldwide are competing for capital, which is scarce. Now, host states face a dilemma. I mean, do we welcome openly investment interests whose goal is to make a profit, and hopefully these types of profits will trickle down to other parts in the host state, whether through employing local people or benefiting somewhat the local economy, and whether we can impose sort of environmental laws, human rights issues, or labor issues. So there is a sort of a dilemma, how you balance these things, because one case can cause a chilling effect, and we've seen how an investor in fortnight just went out of the country and left the country. So it's a dilemma, how you balance these things. I tend to argue that countries or governments favor the economic part, and hoping that through economics, through economic growth, human rights situation can get better. There will be no longer environmental degradation or violation of labor laws. So it's a balance, it's a fine balance. Every country in the world is competing for capital, expecting capital, especially from the side of developing countries. And you could argue that they're not doing this on purpose, but there is so much difficulties economically that they perhaps put the human rights issues on the back seat.
Thank you very much, Bashar. And now we're going to move back to Ireland with Kieran and Chiara, who is incredibly prolific in terms of articles. I'm really impressed. So we will now listen to your presentation. So we've already introduced Chiara earlier. Kieran is also a lecturer at the School of Law in Queen's University in Belfast. Both of them come from the business and human rights, from a corporate governance background, and are interested in how themes and theories from corporate governance can be understood throughout business and human rights. Previously, they have written together on judicial constraints on remedies potential, as well as on the national contact point. This paper focuses on the role of national contact point and how this can be effective or an ineffective pathway to remedy for victims of human rights violations. The floor is yours. Thank you very much.
Many thanks, Claire. I hope I can share my screen with you. Let me do that. Okay.
Yeah, we can see it.
Thank you. Oh, it's moving already. Yeah, so that's not the title of our paper. That's the main point of our paper. I think we're quite interested in remedy and the role of remedy and access to remedy through OECD national contact points. But in our discussion, I think what emerges is a real sense of human rights coming out as a corporate governance phenomenon, as something different to what they were before they encountered the corporation. I think that's our main point. I think Ciara will take this slide and the next, and then I'll step back in.
Okay, thanks, Kieran. Thanks, Claire. Okay, so we're focusing in this paper on the OECD guidelines and specifically on the 2011 update, which introduced Chapter 4 on human rights, which aligns in a way with the UN guiding principles on business and human rights. We feel that as a CSR instrument, it has in fact been repurposed and rebranded with its alignment with the UN guiding principles to a point where it could be viewed as a type of hardened soft law. Kieran, if you want to shift to the next screen, please. Okay, but more interesting for the OECD guidelines is actually the national contact points. So the national contact points were set up in 1984, and they were tasked with, on the one hand, promoting the OECD guidelines, but on the other hand, to manage specific instances. And these were cases where individuals or corporations or organizations challenged the interpretation of the guidelines, or indeed argued that there had been a violation of the guidelines. So this specific instance procedure comes about in 4 phases. The first one is the initial statement, where after a brief fact-finding mission, the national contact point will decide whether to accept or reject the complaint. If they accept the complaint, then they make an offer of good offices. And basically this will allow them to bring the parties together in a form of mediation to conduct the investigation. After this, there's a conclusion. There's final statements. If there has been no agreement reached, the national contact point might still make recommendations. And then a year after the conclusion has been published, there is a follow-up procedure to see have recommendations been followed. So the key thing to be aware of is that national contact points are not judicial bodies. They cannot impose sanctions, rather they are vehicles for mediation between the relevant parties. And as such, they do very much rely on participation and goodwill from all the parties involved, be that the complainants or indeed the organisation that they're complaining against. With the arrival of the guiding principles, and particular Pillar 3, you have mentioned in the commentary on Pillar 3 of the United Nations Guiding Principles that the NCP is a non-judicial grievance forum which can provide a suitable remedy for human rights breaches for victims. For some organisations, this might be part of the attraction, particularly with regard to NGOs, but we would argue that this maybe does alienate the actual victim, and it does classify the type of victim that can actually have a successful action under the OECD guidelines for multinational enterprises. And as you can see there, the experience with the national contact points vary greatly. If you can look at Kieran's chart in the top right hand corner there are 4 NCPs that are involved in 40% of the complaints, with the United Kingdom being involved in 75% more complaints than the USA. So I'll put that back over to Kieran, and he can talk you through the approach that we took and the method that we took for this paper.
Thanks, Ciara. Yes, in terms of approach, we've collected data from OECD Watch, which is a consortium of NGOs based in the Netherlands, with SOMO in the Netherlands, that monitor the complaints that come into national contact points worldwide and collect data on them. In fact, OECD Watch is perhaps more accessible, certainly, but more comprehensive than the OECD's own site to do with national contact points. I'll just talk a little bit about the United Kingdom's NCP, which is our study subject for this paper. The United Kingdom is, as you can see from the previous graph, a highly active national contact point. National contact points, they very often will be involved, or a complainant will approach numerous national contact points, and one will be nominated as a lead. So very often the UK is involved in complaints, but it may not be the lead. It more often is the lead, but it will be joined by other NCPs. And the UK National Contact Point is situated in the Department for International Trade. It's very active, but not only on in promoting the OECD guidelines and answering complaints, but also it works on modern slavery, on due diligence guidelines for supply chains, as well as more traditional NCP activities. It's regarded to a large extent as a good a national contact point, in the sense that its procedures are transparent and that it's highly active, but it has been heavily criticized. So, for instance, by a report by Amnesty International in 2016, they criticized it in part on the number of complaints that have been rejected at the starting point by the UK NCP, and you can see in the chart on the left. The number of rejections in brown there, the number of complaints that were rejected at the point of complaint, but also the Amnesty and others have expressed disappointment at the degree to which the UK National Contact Point has been willing to challenge corporations that have been uncooperative or that have that themselves been untransparent in terms of delivering information and responding to complaints. And OECD Watch indeed criticised them and other NCPs in terms of the lack of access to remedy. There, though, we should note that because NCPs are non-judicial voluntary mechanisms, they cannot impose a remedy on firms. They work in pursuit of mediating an agreement through their good offices, as Kira said. So sorry for the very busy slide there. So in terms of method, we took the 83 complaints that have come through the UK National Contact Point and sought to classify them by who brought the complaint or on whose behalf was a complaint brought, what was the character of the complaint, and what kind of remedies were requested, and what kind of recommendations did the National Contact Point deliver. I think it's important to say two things about our method. Although there have been 80 complaints, these these worked or they articulated a series of campaigns. So you would find a group of complaints brought by a complainant that all really pertained to a single problem, be that some aspect of an extraction process in a mine somewhere, or a problem with collusion, for instance. So a good example of that is a series of complaints that were brought around Guantanamo Bay by a single NGO, but they are split into different complaints, or a series of complaints that were brought around British Telecom, for instance, and its collaboration with state forces in terms of drone warfare in Yemen. You find in the OECD data set maybe 3 or 4 complaints there, but they all really pertain to one campaign and one issue. So when analysing the complaints, they're not really amenable to kind of more traditional quantitative analyses, because once you account for campaigns, the data set becomes quite small, and therefore we're not making kind of regression analyses of the data set. We're simply making descriptive observations. One thing that we did note was the degree to which complaints by individuals or on behalf of individuals tended to be rejected by the UK National Contact Point. In fact, the only ones we found that we classified in this way, and it was a pilot operation, we'll have to, return to it and refine our analysis. But the ones that we saw were rejected. The only ones that haven't been rejected, there simply hasn't been a decision made about them yet. Complaints about specified groups, where there's a named group, a village, or people who surround an extraction activity, for instance, tended to bring more mixed results, etc. It's also worth noting that complaints were brought on the whole by specialist non-NGOs. So you can see in the table there that RAID, for instance, made 11 out of the 83 complaints to the UK NCP, although again, around about 6 campaigns, Friends of the Earth made 6 complaints, around 4 campaigns, and you can work your way down. At the bottom, the complaint from Hungary, the interpretation of that complaint was that it was extortion, that it was a single individual who was looking to complain in order to extort money from the firms they were complaining about. They had said to the firms, if you give us money, we'll withdraw the complaint. Whether that was a hunt for a settlement, perhaps awkwardly, or whether something dishonest was happening, it's impossible to tell from the data. And complaints that involve allegations of collusion with states, I found quite interesting. They met with quite a bit of resistance from firms, but interesting resistance, because they refer to these are legal operations in the view of the states that we, the firm, are cooperating with and have contracted to deliver services to, or there are matters of security or commercial confidentiality that mean we, the firm, can't respond to the complaint. And that's quite interesting, because it reflects the NCP really starting to demarcate and then police boundaries about what they will count as a legitimate complaint to a national contact point. The complaint, it would seem, has to be very much about the business in a private capacity. Once the complainant starts making allegations about the business in cooperation with states, then the NCP seems a little bit less reluctant. On the first initial run through the data, quite a bit less reluctant to engage. Of course, specialist NGOs may not be bringing complaints with a view to success in the surface sense of finding some path to agreement or finding some financial remedy. Their grounds for bringing the complaints might have to do with pressuring the firm and being part of a broader campaign of pressure to a firm around their conduct. So what did we find? As you can see, once we account for campaigns, we're not looking at big numbers, but when complainants bring complaints, they look for a certain kind of outcome. Most often in our reading of the data, they want the current harm to end. So some harm is being imposed upon a population, and we, the complainant, want that harm to end. Or they want improved processes, very often improved engagement, but also improved human rights processes on the part of the firm. And thirdly, complainants are looking for financial compensation very often. A harm has been incurred, the remedy is financial. But after rejections have taken place, the few campaigns that we end up with where there has been either an agreement with a firm, so the NCP through its good offices has brokered an agreement, or where the NCP has brought the complaint to a conclusion, but without an agreement between the complainant and the firm, but the NCP has made some statement about its view on the problem and how it ought to be resolved. we basically don't see any real reference to financial outcomes. I think there was one, and we see less of a reference to ceasing the current harm, although that can come into it. What we see far more of is an appeal to the firm to improve engagement with local communities, with complainants, or to improve their processes around adherence to the recommendations of the OECD guidelines. So that in itself descriptively is what we think is going on, but we think that this reflects something about how human rights interact with the kind of ecosystem that sits around the corporate economy, the global corporate economy, and around corporate governance. And we see the NCP in a sense as being part of that ecosystem, as part of really trying to negotiate human rights as a business phenomenon. And that's what happens with business and human rights. Human rights become a business process, something that is put to work by businesses. So we see the NCP and this kind of work through these processes, moving away from cease the harm, move away from finance, and move towards improved engagement, improved discourse, and improved auditing and other due diligence processes, as being about the corporatization of human rights. So second last slide, which I'll run through very quickly, and then a conclusion. So the narrow scopes for agreement see the NCPs facilitating the broader shift in what human rights come to mean when they encounter business processes. Rights are assimilated into business processes for good and ill. I think we wouldn't be recommending that business and human rights be thrown out. There's very good outcomes here, but nonetheless, human rights become a thing that becomes kind of reported on as auditable, measurable, and procedural primarily. So, and in part through the NCPs, rights are retooled and put to work as internal business processes rather than as radical challenges to the impact that businesses can and do have upon societies. So our conclusion is that state-based judicial mechanisms focus on the particular harms to particular individuals now, but they're quite laden with barriers and react to a harm that has happened. But the kinds of non-judicial grievance mechanisms like NCPs focus on the responsibility to reflect, and they've shifted the discussion and the discourses around human rights into something that's forward-looking and procedural, into the procurement and production of commitments towards future conduct. So it's more accessible, it's more amenable certainly to firms, but it engages less with the breach at hand than in a collective approach to mitigating future breaches. And we think that we must, as scholars, pay serious attention to the evolving character of rights themselves as they come to be negotiated in such forums. When rights are tamed in this way and are made amenable to powerful actors, they are transformed. So business and human rights, including through NCPs, becomes a discourse of corporate power in society that is formed by, shared with, and put to work by corporate actors. I think that the key thing here is, that the corporate actors will engage with human rights as long as they don't disrupt the core business processes that they already have. Human rights become part of those core business processes. And unless Ciara has anything to add, I think I'll finish there.
Thank you very much, Ciara. And maybe now we will give the floor to your discussant, Elif Argun. Please, the floor is yours.
Thank you. Thank you so much for your presentation. It was really insightful and comprehensive to understand the real position of the NCPs, particularly in the UK. After reading your article, I had a look at the OECD Watch 2015 report and noted that only 1% of 2050 complaints had resulted in an outcome which directly improved conditions for victims of corporate misconduct. It's a really astonishing low percentage. And from Canadian perspective, I noted that in Canadian NCP received only 20 specific instances between 2001 and 18, and no specific instances last year. So even I note that in a comparison, NCPs are failing to prevent harm and to facilitate access to remedy, as you elaborated in your paper. Maybe you can add some details how they fail to facilitate these purposes. For instance, in the Canadian experience, I note that lack of independence has been one of the criticisms, because the committee is composed of representatives from governmental authorities. So at the end of the day, they somehow represent the governmental political approach to the issues in the table. Also, I noted that there might be unjustified delays in the processing times. Maybe you can also give some details how this process take time compared to the prescribed period. And as you noted, the application of thresholds for acceptance complaints are different, and the NCPs tend to apply a higher threshold to accept new complaints. Maybe giving more examples in terms of these higher thresholds, you can give more information how these individual complaints are facing with what kind of problems. As a related note, again from Canadian perspective, and as you indicated, international extraction, mining sectors are the most important sectors that NCPs might have played a better role, but somehow failed to do so. Here, federal government had appointed an ombudsperson for responsible business enterprise. The aim was to tackle the shortcomings of NCPs, but at the end of the day, this ombudsperson office also failed to grant remedies, because it's not an independent office and it doesn't have real powers to investigate abuses and redress harms. Do you think, in your opinion, would introducing an independent and effective office of ombudsperson would help to tackle shortcomings of NCPs? Or do you think that this solution would draw human rights back to the corporate social responsibility sphere, and it would demerit the potential of human rights approach? Do you think would that be a better solution, or just going back to the same circle again?
Kieran, I'm happy to take this, or yeah. Okay, thank you very much. That's really useful. You're right. Certainly there's places there where we could be providing a lot more detail. With regard to the independence, so the OECD Watch website, which, as Kieran said, is much more useful than the actual OECD website with regard to the guidelines. They do set out components for assessing how independent different NCPs are. So some NCPs are much more independent than others. Now, I don't know if any that actually have an independent ombudsman attached to them, or they've taken that route, but some are perceived as being very independent, but the response seems to be quite similar, as in there still seems to be a majority of rejections and so on. So I don't know if the independence would have that great of an overall impact, but where it might have an impact is in those cases in the slides where Kieran mentioned about allegations of complicity between states and corporations. There might be an advocacy there for having a more independent figurehead. But it certainly is a really interesting point, and I didn't know that about the Canadian, the federal ombudsperson, so I have made a note to go and check that out, so thank you very much. Kieran, maybe did you want to come in about the specifics on anything there, or are you happy enough?
Yeah, no, thank you very much. That was really, really interesting.
Sorry, perhaps just very briefly, because then we'll need to move on to the next speaker. Just
okay,
so
I'll make one point. I think it comes back to Bashar's paper in lots of ways. If the NCPs were effective, I'm not sure that they'd exist.
you.
Thank you very much for that. And then with that, we go back to Elif for her presentation. So now we move to Canada. And thank you very much for being with us today. So Elif specializes in mergers and acquisition, transactions, joint ventures, and corporate restructurings. She advises clients in a broad range of sectors on corporate and commercial legal matters, especially in the emerging markets, particularly in Turkey. She's a graduate of Co University School and holds an LLM degree from Queen Mary University in London. Prior to moving to Vancouver, she worked for leading law firms in Turkey and advised multinational corporations. She's currently going through the accreditation process in order to be admitted to the bar in British Columbia and working in a Vancouver law firm. Elif, the floor is yours. You have 10 minutes. Thank you.
Thank you. Thank you so much for the introduction, and I'm really pleased to be here with you today. As mentioned, I have worked for numerous corporate clients over the years, and I had the opportunity to observe business practices of transnational corporations while they are operating in developing countries like Turkey. And I noted that due diligence terminology is misleading from a business perspective because it fails to go beyond a tick box experience, and most of the time they recognize it as a risk management exercise to minimize reputational or litigational risks. Also, in countries where the rule of law is not respected and an independent judiciary is absent, corporations are more reluctant to take positive steps to follow the UNGP principles or OECD guidelines. And in an overwhelming majority of the M&A deals, the only red line for our clients had been tax liability. As long as there is no high risk of tax exposure, they proceed with their investments in the developing countries, and no matter how unsettling the rest of the due diligence findings may be. Today, I want to briefly talk about corporate citizenship and inclusion of tax behavior in the human rights due diligence process. And corporations as artificial institutions created by the states, I think we should first revisit the relationship between the state as the trustee or as the power holder and the individuals as the beneficiary or right holders. In this respect, the overarching aim of the state should be to ensure that all legal persons under its sovereignty enjoy their rights within the boundaries of human rights. And corporations can legitimately exercise their property rights as long as they don't deprive individuals of their basic human rights. UNGPs is regarded as the most widely accepted framework for responsible business conduct. Calls for the corporations to meet their responsibility to respect. And in order to meet their responsibility, corporations should have a post-commitment and HRDD process and the remediation process in place. And during this human rights due diligence process, we note that the salient human rights issues most of the time focus on the forced labor, which is in most of the cases in developing countries can be found in the situations of child labor and unsafe work environment, discrimination and harassment, community rights, property rights, and labor rights. I believe that adding irresponsible tax behavior is really crucial in order to have a complete human rights due diligence impacts assessment. As set out in 2015 report, Getting the Good, tax responsible corporations should be able to publicly justify their tax planning choices. They should be more transparent, and they should assess any human rights impacts of any significant tax advantages, transactions, and restrictions. And inclusion of responsible tax behavior in the HRDD process is also compatible with the UNGPs as set out in the commentary to UNGP 12, depending on circumstances, corporations may need to consider additional standards, and I believe responsible tax behavior should be one of those standards. As we all know, tax behavior of firm may range from tax planning, which is totally illegal, to tax evasion. And corporations most of the time argue that even aggressive tax planning is not illegal, but its effect on vulnerable groups cannot be denied. And as Alison Christian suggests, to solve the corporate tax avoidance problem, fulfillment of human rights should be the main aim of the taxation. And as this slide shows, tax should be considered as an expected return of the state. As states, on behalf of society, provide social capital in return of taxes, and they provide social capital in the form of education, healthcare, transportation, security, legal systems, subsidies, and support for corporations.
Elif, maybe we can't actually see this slide, so I don't know if you want to try and resharing that. Sure, just resharing your screen. If you stop sharing and start again, maybe we'll see it.
Can you see it now?
No. No, we just see a blue screen.
Sorry.
It's okay. Yeah, perfect. Now we can see it. Thank you.
Yeah. In terms of the main constituents of a corporation, shareholders contribute with their financial capital and expect dividends as returns. Employees contribute with their human capital and expect wages. And state, as on behalf of the society, contribute with social capital and in return expects to receive taxes. But in the practice, I've seen that many years taxes are always considered as a deduction from the financial capital's dividend returns, and it should be something that we should avoid no matter what. So I want to also talk a little bit about HRDD in terms of raising awareness and building public trust and engagement in the HRDD process. As recent studies also confirm, stakeholders find the existing HRDD frameworks inefficient, ineffective, and coherent. In my opinion, mandatory human rights due diligence laws are needed more than ever to provide all stakeholders with sufficient information to make informed choices. And also inclusion of tax responsible behavior would encourage long-termism in corporate decisions making and contributing to the well-being of vulnerable groups. Although the recent developments in the EU states, there are still no concrete developments in the developing countries, which form a huge percent of the global value chains. And I think that from corporations' point of view, also mandatory human rights due diligence will create a level playing field. So each corporate will play by the same rules and incur similar costs, ensure legal certainty with clear set out expectations, and help to mainstream good practices in the global value chains. The 2019 Corporate Human Rights Benchmark results highlight the need for state action and for more mandatory measures. The benchmark, assessing 200 of the largest publicly traded companies, have reported that nearly half of these 200 companies scored 0 across all indicators related to process of HRDD, and the average score was only 3.2 out of 15, which confirms the poor levels of implementation of UNGPs. And as an example, Amazon only scored 3.9 out of 25 under the HRDD section, failing to score any points on many indicators under the HRDD which includes assessment of risks and impacts and accounting for how human rights impacts are addressed. Lastly, I want to briefly talk about some alternative solutions beyond corporate law. As we are waiting for convergence on mandatory human rights due diligence legislation, I believe that we should be also looking for alternative solutions beyond corporate law. And from Canadian law perspective, as a suggestion to initiate a dialogue on alternative mechanisms, constructive trust may be revisited. Pursuant to the Supreme Court decisions, constructive trust had two main functions. The first one is the reversal of unjust enrichment, and the second one is preventing wrongful conduct, which is justified on the basis of general deterrence for future wrongdoing under the overarching goal of maintaining confidence in societies. If we can apply these principles to the corporate human rights violations, then a claim of unjust enrichment may be asserted to the parent company to the extent that it can be proven that the parent company has received a benefit, the right holder suffered a loss corresponding to such benefit, and there were no juristic reasons justifying such enrichment. On the second part, a claim of unjust enrichment by wrongdoing may be asserted by corporation against the directors. As directors owe a fiduciary duty to the corporation, while the content of such fiduciary duty would be context specific, the Supreme Court underlines that at minimum, directors should ensure that corporations should meet their legal obligations. Recently, the Canadian Supreme Court in Nevsun Resources case in February of this year has confirmed that customary international law norms form part of Canadian common law, and accordingly, corporations may owe human rights obligations under customary international law. We'll see the details of this legal battle in the upcoming year, but it's a promising decision, and going forward, I believe that inequality and unsustainability, which are the two main issues of today, can be tackled through adopting a sound tax system, promoting social inclusion, and preventing unjust enrichment of corporate players. And I think in order to achieve this, a multidisciplinary approach is needed. And by this way, we can shed some light on the contexted notion of good corporate citizenship.
Thank you very much, Elif. I will now give the floor to Bashar, who has 5 minutes to discuss your paper. Thank you, Bashar.
Thank you for excuse me, for this wonderful paper. I really enjoyed reading the paper. You discussed so many issues in the paper. You talked about the holistic approach and how to achieve inclusive and sustainable development, that the board of directors of a corporation not only owes fiduciary duty towards shareholders, but rather other stakeholders, and human rights concerns should be taken into account. You touched also on some of the theories that involve corporation as a separate personality, the economic theory of the firm. And what is intriguing in your paper, and you did rightly so, that you mentioned that there is lack of jurisprudence that would necessitate looking into other alternative. And I found it very interesting when you touched upon and discussed the issue of tax policy. And I would have loved to see more of the argument on the side of the tax policy, and how tax policies can be tweaked or twisted one way or the other, so as to accommodate human rights concerns and other issues. But my question is, did you encounter any cases or that involved social aspect of the tax code, and whether how real the issue of using the tax policy to advance other interests besides again economics. I mean, and this is a huge issue in the US. It's always the theory that a tax policy by, for example, lowering the tax, if you're a Republican, this means that you will get a better chance for economic growth, and those on the Democrat sides would argue of increasing the tax on the 2% on the wealthier part of the U.S. society, so the effects would trickle down. But my main question or comment: how do you think that the tax code can be amended so as to accommodate other interests, and how real that would be as an alternative for other measures that failed really to advance the economic theory of the firm beyond taking account of the real beneficiaries, which are the shareholders? Thank you.
Thank you so much for your comments, and I agree with you. It's up to discussion how feasible it can be in the short and even medium term to realize that aim. I had looked at it, but haven't yet come with any jurisprudence on the application of the tax perspective. It's just, as you said, depends on the political attitudes of the players, and it's a long way to go. But ultimate aim should be that when we are discussing the changes by the ultimate aim should be that the equality cannot be provided in the absence of these regulations, these amendments. And if the change comes from the society in the form of a behavioral change, when the concerns and NGOs, the concerns of the citizens and the NGOs continue to push forward for this political agenda, it may proceed, maybe in the upcoming years, but I agree with your comments.
Thank you very much, Adi. Thank you, Pasha. And now we move from Canada to Mexico with Professor Humberto Cantu Rivera, who is Professor at the School of Law and Social Sciences of the University of Monterrey. He's also the Executive Director of the Monterrey Institute for Human Rights and Business. He's a PhD holder from the University Panthéon-Assas in Paris 2, and the director of the Latin American Business and Human Rights Scholars Association. Humberto, the floor is yours.
Thank you very much, Claire. And I must say to begin with that I'm very happy that I was able to join this very interesting conference. Thank you for the invitation and for leading this renewed efforts to, disseminate business and human rights in several languages, in several regions. That I think is very valuable. I've set up my chronometer to let me know when I'm done, when I have, when I'm close to 10 minutes, so that I won't go beyond that, because I know I was very strict in my moderation a couple of days ago. But anyway, today I would like to speak to you very briefly about the idea of human rights due diligence from a multifaceted perspective from Latin America. Of course, it's not entirely about Latin America. There's some elements here and there. And I must confess also that it feels a bit like I cheated, because I was not able to produce a full paper, but rather an outline. So apologies to my reviewers who were only able to look at maybe 2 or 3 pages. But in any case, the ideas are there. It's just a lack of time to develop them. Now, I tried to address this specific point of my paper in 2 different parts. One addressing homestead legislation, especially focusing on what's going on in Europe right now and what are some of the red flags that we perceive that may exist as we move forward in this discussion. And secondly, on their need for host states to actually engage in this same logic of standard setting at the legislative level, and on corporate human rights obligations to basically give you a few pointers here and there on some of the developments that have taken place in Latin America in different jurisdictions. So it's not that it is one single judgment that made this case, but rather the opposite, how different jurisdictions are addressing and understanding this topic of business and human rights, even without express legislation addressing that. Now, on the first part, we all know, I'm sure we all know here in this conference, that there are ongoing developments in the European Union, especially at the European Commission, to develop an initiative, a legislative initiative with a regional perspective on mandatory human rights and environmental due diligence. Claire has been one of the most prolific authors and experts addressing that. So of course, I will not dare go into too much detail on this because I would be probably not good enough. But in any case, this idea has been largely modeled, number one, after the French law on the duty of vigilance, the devoir de vigilance, and secondly, after several elements of Pillar 2 of the UN Guiding Principles that I assume most of us are familiar with, which basically stipulates 3 or 4 points. The necessity for businesses to develop an internal human rights policy, whether a standalone or in link with other initiatives that already exist within the company. Secondly, to undertake human rights due diligence processes. So that is a concept that has not been fully understood yet in many areas, perhaps outside of Europe. And thirdly, or North America maybe. And thirdly, the need for businesses to actually engage in remedies. So many of you have already discussed several of these topics, and that is of course necessary to understand how businesses, as for example, Chiara and sorry, I forgot, Luke, sorry. I remembered Moffat, but not the name. Chiara and Luke addressed in their paper. So what are the motivations for businesses to do that? However, the EU initiative on MHRDD, mandatory human rights due diligence, addresses, in my view, 2 specific points. Number one, it serves as a political standpoint. The UN Guiding Principles refer to an expectation that companies will behave properly, but what does an expectation mean in terms of policy? I mean, at the end of the day, any government can say, we expect everyone to behave properly, but then again, it's not the same if we don't have legal rules in place. So to me, that is a way to address that point in the UN Guiding Principles, a political standpoint that serves for that purpose. Secondly, the main focus of this, and I truly appreciate that effort actually, is to ensure that there is legal homogeneity, to ensure that there are similar standards applicable throughout Europe instead of having a scattered legal landscape on this point. But the question, and the main question that I start to ask in this brief paper is, or well, this brief outline, not even dare to call it a paper, is can they be effective as an initiative? Mainly because of one specific point that, curiously enough, was sent yesterday to the Parisian courts in a case involving Mexico, EDF, Electricité de France, the French state-owned, I believe, electricity company, sorry, for actions taken in the southern part of Mexico. And the question about that is that, or the main reason for that question is that there are conflicting obligations that may be adopted at the home state level that may not be fully reproduced or may be entirely different at the host state level. And that poses the question, which is something I did write expressly there, are we on the verge of repeating the exact mistake that took us here in 2005, or that started to take us there in 2005, which is that we have very strong home state standards, but with little enforcement or even standards at the host state level, which is what actually we need to ensure not just adequate protection of human rights by the state, but also to ensure effective access to remedy domestically, instead of having to go to transnational litigation, as this case proves. So that point is something that I'm really looking into, and of course I will be very interested in developing further in the near future, hopefully with the expectation that I can share that with you at some point. But in the 4 minutes that remain for me, I would like to then now turn to what has been going on in Latin America that may point to potential, to the promise of effective human rights regulation in the context of business activities. And I have 2 or 3 points to make here. Number one, we definitely need legislation. We definitely need enforcement, but it is not necessarily the same type of legislation that we would need, or that is going on, or that is being developed in Europe, for example. Why? Because simply the necessities are different, the legal systems are different, and perhaps there is, as everyone acknowledges in many fields in Europe, a hyper-regulation that is not prevalent in other parts of the world. However, this also points out to some of the concerns that I see, for example, in the discussions on the treaty. Many of the concerns about the treaty is that we will pretty much set up a system that allows victims to only focus on going to court in the home states of companies instead of trying to address those cases domestically. We have a very specific case going on right now, and I'm sure some of the Brazilian colleagues that will intervene later know of the cases involving Vale in Brazil for the 2 dam spills, for example. That led not just to domestic litigation, which I see as something very useful and something very needed as well, and where the judiciary has the tools and the capacity to address it domestically, but also an ongoing competing litigation taking place in the UK and potentially in other places, maybe perhaps even in Germany for the certification that was given to those dams. So that tends to reflect a bit of the concerns on why maybe there is this effort to develop a regional legislation instead of focusing on a global level legislation that would actually ensure that we have consistency across regions. But beyond that, I would like to point out then, I mean, I don't have enough time for this, and I knew this was going to happen, but 2 things. For Latin America, and we see this very clearly in the case law that I'm going to quote very briefly in a few seconds, we see 2 elements: constitutionalism as a main starting point, which is very relevant and perhaps a bit different than in Europe. And number 2, the inter-American human rights system's influence in domestic jurisdictions, essentially because of the pro persona principle. What does that mean? That any state authority, including the judiciary, will be forced or expected to actually implement any decision based on the most effective or most protective standard that there is, regardless of whether it is of a conventional or constitutional or legislative nature. So that gives us a very wide range to address this. And we see several cases where due diligence has been actually explored in practice. We see the Ocensa case, which is very similar to the ACPAN case that was litigated in the Netherlands a few years ago. In Colombia, where the court actually said that there is a due diligence standard and expectation that is set upon the company to actually engage and foresee the potential risks and act in accordance with them. So that's one. There's been other cases involving, for example, this idea of the influence or control between one company and the other, regardless of the fact that this was not precisely a parent subsidiary relationship. It was basically on the basis of the use of a brand name and the duty of that brand to actually ensure that certain elements are respected by the other companies using their brand in Argentina in a case of sexual harassment. And we have other cases in Mexico and Brazil as well, where we see how due diligence is being interpreted in much more detail to actually advance and provide us with actual standards that are there, interpretations that are there, and that can help us understand as well how this North-South relationship may work in practice, but also how to ensure ownership at the domestic level. Finally, my last point, and well, I can of course expand a bit later on, is that the role of interest, the role and interest of home states in this discussion, especially when we look at the projects of the EU in the region as well as in Asia and in other parts of the world, should be to ensure a level playing field through the use not just of commercial and investment agreements, for example, which are very useful to set up the conditions for that, but also in their economic diplomacy. I'm sorry, not just the economic diplomacy, but also in their quest to ensure that there is consistency in their role domestically, at the domestic market, and externally with their partners in other regions of the world. I apologize for going overboard for a minute and a half, and I'll stop there to, well, just continue the program. Thank you, Claire.
Thank you so much, Umberto. And then we'll give the floor to Chiara and Luc for the discussion. You have 5 minutes. Thank you.
Thank you, Umberto. That was really interesting. Really enjoyed it. Unfortunately, I didn't see the outline, but hopefully I've got enough of it here to be able to give you some comments. I was quite interested in this from a number of different perspectives. So when you talk about the European mandatory due diligence procedure, I was interested in the focus to achieve legal homogeneity. Now, this is something that I find quite interesting. Did you uncover, maybe Claire, this is a question that you could perhaps answer, has there been much concerns from different regions within the EU about trying to get this baseline? And the reason I'm saying this is from concerns when they've tried to harmonise tax and so on within the EU region. Certainly for regions like Ireland, they're very against that, obviously because of their 0% tax. But I wonder, is that something that comes across within regions with human rights due diligence as well? Because I find it very interesting the way you were talking about the different domestic approaches to human rights due diligence within Latin America, and you talked about Colombia, the due diligence standard and expectation, and really the richness of information on, or the richness of quality and interpretation of human rights due diligence in the Argentinian, Colombian and Brazilian courts. And I wonder, would a regional standard lower that baseline and limit the potential for these domestic level really invigoration of what can be achieved with human rights due diligence? So I'd be interested to hear your views on that. What else I would love to hear more about the enforcement mechanism. That was really interesting. But perhaps that's maybe for another day. But I'll take it on that. Look, unless you have anything in particular to add there.
No, thanks, Kira. Humberto, I thought it was really interesting. I cut across a lot of areas I've been exploring as well. I think it's interesting bringing in the Inter-America system and how it approaches human rights, because as you well know, traditionally it was about trying to transition countries to more constitutionalism, and now it seemed to be in even a new sort of space now where it's looking at the broader role of private actors and how that sort of fits in. And I think one of the things with due diligence that maybe also reflects on maybe different regional approaches around the world is also issues around the absence of the state. And I know from talking to some lawyers in Medellin that for them that was a big challenge, where you have corporations who got so much power and there is very weak or absent state structures in rural areas. How do you sort of improve court systems where for people that armed groups control the territory and multinational corporations are trying to get access to resources and using the means and methods to do that, where the state is absent. So I don't know. There's a bigger effort of the role of the state, and I suppose there's something about the hegemony of the state that we're thinking about as well. And in that sort of notion of hegemony is, yes, you've got the European Union and places like Colombia, but there's always the shadow of the US, and with the politics there and how it's standardized, how its operating practices with corporations. I don't know, I think it's quite corrosive sometimes that when we talk about human rights, we're still struggling to move things forward, yet we continue, we're in a really fragile time with human rights, and trying to get better due diligence for corporations when we've got quite political and economic powerhouses and trying to undermine it at every corner. So I think it's really interesting, the paper, and I look forward to seeing and reading it. So I think that's more just general thoughts than anything. So thanks.
Thank you, Luke and Chiara. Well, number one, about homogeneity. Well, I haven't looked actually at the other elements, but what we see in many of the approaches that are taking place right now is that, for example, we have, states are trying to tackle different elements of human rights due diligence. And that in itself leads to this very diverse regime where there is, of course, no sense of unity or of a common purpose. And that in itself is something that I believe can be tackled by this EU initiative. Let's see if it works out. I mean, at the end of the day, it's still a political negotiation, and not all states will probably be in favor of the same approaches, but let's see how that moves forward next year. About a regional standard limiting the potential. Well, I assume you referred to Latin America?
Yes.
Okay. Well, that's one very interesting thing, because even though we have the Organization of American States, it is nowhere as close as the EU in terms of political and legal organization. But nevertheless, the Inter-American system and the Commission especially serves sort of as a rallying point in that regard. And therefore, what I can actually point out, and this links to Luke's comments as well on the Inter-American system, is that with the report that was issued this year on business and human rights, we will definitely see many more courts addressing the topic, because they largely, in many cases, rely on this, especially constitutional courts, right? Not lower courts, unless plaintiffs or defendants actually argue something about that. But I do believe that instead of limiting the potential, it can widen the potential of human rights due diligence as a standard of conduct that already exists in civil law. So it's nothing new at all, and exists as well in criminal law in many countries in Latin America that have corporate criminal liability, which is something really interesting. What we will see, I think, is the refinement of this standard through case law in the near future. There will be difference. Every case is different at the end of the day. But I see that instead of limiting the potential, it will allow for states and for judiciaries actually to expand on that potential. And about enforcement, well, that is the big question. How do we ensure that there is enforcement of this legislation? And I think the best approach, and this is something that has been discussed recently across, well, with many colleagues in the Americas, especially in light of the treaty negotiation taking place in a few more days. The standard, and this is something that you actually referred to in your presentation, Article 8.8. That is really interesting, because in many legislations in Latin America and different countries, we have the standard where if a company actually performed due diligence or acted diligently, regardless of the fact that there is no standard per se on business and human rights, that may lead to an aggravation or to diminishing actually the punishment that they will receive, not just in criminal law, also in civil law. And I think that in itself will, little by little, if we take this conversation more into the public eye, allow for better enforcement directly by companies, better application actually by companies, but also to more attention by states on what needs to be done. Because at the end of the day, what we see in the region is, in my view, a reposition of the state as a central part of the economy, something that was lost there for a few decades, maybe 2 or 3 decades.
Thank you very much, Humberto. Thank you to all of our speakers for these fantastic presentations and lots of food for thought. In the 10 minutes that we have left, I'd like to open the floor to the audience to see if anyone has any question. Please, you can use the raise hand button or write in the chat. While I give the chance to people to formulate their ideas, I will also use my prerogative as a chair to ask questions, if that's okay. So maybe that's a sort of general question that came to me to all the panelists. But I think if we try and link these different topics that have been touched upon today, with a lot of emphasis on access to remedy or sometimes lack of thereof, and then the means to prevent corporate human rights harms, which is the human rights due diligence. And Alberto was just saying, just right now, talking about, if I understood properly, in Latin America, there's some systems that have recognized that undertaking human rights due diligence will diminish liabilities. Is that correct? Is that what you're saying? Yeah. So how can we link these two and yet thinking about the legislative developments that are occurring, do you think that these are two elements that need to be linked, the access to remedy element and the human rights due diligence, or do you think that these are two elements that should be separated, as in undertaking human rights due diligence shouldn't exclude the possibility for victims to actually be able to get damages, even if the companies actually did their due diligence and did it properly? I am not talking about the sort of tick box exercise there. So this is kind of a question that I'm posing to the whole panel or anyone who would like to take it.
I may start, if that's okay.
Yes, please.
I think it's absolutely crucial to, number one, grounds the UNGPs and especially Pillar 2 on existing legal systems. The failure of John Ruggie and the UN in general to do that from the start has made it very complex for companies to understand that there is an actual legal risk that depends and exists, that existed independently of the UNGPs, independently of domestic human rights due diligence legislation. I mean, it is there in many systems. I cannot talk about every single one, but in civil law systems, that is the norm. And it brings to mind actually something that I read with much interest a couple of weeks ago by Hervé Asensio from Paris 1, from Sorbonne, who was writing about the OECD guidelines 2 years ago already. And I remember him writing that while it was interesting that France had adopted a law on the devoir de vigilance, it is absolutely irrelevant for the purpose of civil liability. So I think they are already clearly linked. At the end of the day, under civil law, in civil law jurisdictions, there is this very clear notion that whenever anyone causes any damage, he or she or the company is breaking a general existing duty to prevent impacts on third parties, regardless of the type of characterization that we make of those impacts. So it's not just necessary, it's actually a fact, a legal fact that is already there. The question, and I think Shift in a document that they produced a couple of days ago, mentioned it very clearly. It is there. I mean, it's nothing new. We're just talking about it from a different angle, but it's something that already exists.
Thank you, Umberto. Do we have any other panelists that wanted to add something on this, or perhaps add questions to the other panelists? That is also absolutely fine. No. So I also had another question on the so the presentations in particular that concern non-judicial mechanisms, and although there is a lot of work to be done in that respect to improve access to remedy, also through non-judicial and non-state-based mechanisms, isn't there a risk also to go towards a sort of privatization of justice? And would that be something that is desirable from an access to justice perspective? And perhaps here, my question is more geared toward Chiara and Luc, and perhaps Karen as well, if you have any thoughts on that.
Yeah, thanks, Claire. Yeah, I think our big thing with reading more around the non-judicial rights, and particularly, non-judicial grievance mechanisms, was the fact that it didn't concern the victim in the here and now. The victim was in the here and now was a witness, almost like criminal civil distinction. They were just a witness or a piece of evidence to the type of behaviour that a corporation was carrying out. And to that effect, we think that there is a role for non-judicial state-based grievance mechanisms, but that mechanism is very much about changing procedure. We didn't feel that that is an effective method for victims in the here and now. With regard to privatising remedy and privatising that kind of access route, that probably is something that needs to be explored. Now, it does bring with it its own problems, but it maybe deals with the issues that Elaf had raised about the independence of, for example, the NCPs, which could be one of the reasons why there is so few of them to be successful. But my own person, I don't think this is maybe something necessarily that Luke and Kieran share, would be that the problem is how we think about remedy. And I think how we think about remedy and how businesses think about remedy, how NGOs think about remedy and how state think about remedy are all very different. And perhaps those different approaches doesn't come across very well in, for example, commentaries on the guiding principles, commentaries perhaps on even on the new proposed draft treaty. I think that there is one view on what a remedy is, and that view is a bit exclusionary to those different interpretations, and it is the victim that is losing out.
Thank you very much for this insight. Kieran, yes, please.
Sorry, I just wanted to add one thing to what Kira said very, very quickly. The non-judicial, I think one of the things that certainly the way I'd see the non-judicial mechanisms working is that rights are being negotiated, or what it is to have responsibilities towards rights is being negotiated through those mechanisms. But I'm not sure that I'd say that that's not, there's a double negative. I'm not sure I would say it is not the case about harder mechanisms as well. You know, law is a process of negotiation between its authors and its subjects. And so perhaps it is just the choice of and the direction of travel towards the softer mechanisms is itself very telling about what's happening within business and human rights at the business end, I think is what I'd add.
Thank you very much for that. If we have no more questions, we have now reached the end of the time for our panel. So I would like to once again thank everyone, thank the speakers. It was a really great pleasure and an honor for me to be here with you today to discuss these very important issues, and thank you to the audience as well. And we'll resume for our third panel of the conference today in 15 minutes. So thank you everyone, and bye-bye.